eager for the off. I appear for the appellants, Altana, and Brevent. That's the first and fourth defendant, with Mr. Longstaff. Illiquidx, who I'll probably refer to as IX going through, is represented by my learned friends Mr. Green, King's Counsel, Mr. Vinyl, and Mr. Wall. We've discussed timing, and the aim, subject to your Lordship's approval, is that we divide time equally, leaving me time for reply. So the aim is I will stop by 10 to 3 this afternoon, which gives me 20 minutes or so to reply. This case concerns the alleged breach of a contractual duty of confidentiality owed by the appellants, Altana and Brevent. Altana and Brevent are the parties to the NDA containing that obligation. IX is the other party. IX also relied at trial on an equitable duty of confidence that was held by the judge to be coterminous with that imposed by the NDA. As the judge records, while that was pleaded, by the time the trial came round, it was common ground that only the contractual term was relevant, really. The second and third defendants are individuals who are held by the judge not to be liable on the basis that IX did not show that they knew that the information that was held to have been misused under the terms of the NDA was IX's confidential information as defined. So Mr. Robinson and Mr. Kastner are not party to the appeal. I know there were some questions earlier about whether they were, from listing, as to whether they were represented or not. They're here, but because they're not parties, they're observing. The structure of my submissions will be first to introduce you to the issues on the appeal. Then I'm going to go to the judgment, emphasising on that visit the matters apart from construction and specific factual findings that we challenge on appeal that we say are particularly important to the context of the dispute. And part of that is what we say is the extraordinary way that the business opportunity was pleaded and how that changed in IX's case up until closing. And that we also rely in particular on the judge's findings as to no liability for the personal defendants. And then I'll take you through grounds of appeal in turn, returning to the aspects of the judgment challenged. I hope to do construction by reference mostly to the clauses of the NDA as set out in the judgment. The respondent's notice doesn't have much in my submission. If it appears relevant, I'll address it in the context of my submissions or in reply. So, introduction and summary. IX is a brokerage which specialises in brokering illiquid investments to regulated fund managers. So, IX's skill is to identify and provide opportunities to funds. Altana is an investment fund managing company with significant expertise in setting up and running funds, and which invests in a wide range of assets. Mr. Robinson, the second defendant, is an FCA-regulated professional, has been for over 30 years, and he's the founder and controlling shareholder, chief investment officer of Altana. Brevent is a consultancy through which Mr. Kastner, the third defendant, provides his advisory services to Altana, amongst others. He's the sole shareholder and director. So why that's important is the knowledge of those two entities, Altana and IX, is very much, can be pretty closely equated to the knowledge of Mr. Kastner and Mr. Robinson. The joint venture in the NDA came about because IX wished to find a partner to set up a fund and source investors for the purposes of investing in distressed Venezuelan assets. That included both Venezuelan government and state oil company bonds, which were the subject of US sanctions, but which the judge held were widely known to be capable of being invested in a sanction-compliant way. But it also concerned other specific investment opportunities that the parties to the joint venture contemplated that IX was going to source, but which they never did. So this was, although there's a dispute at trial as to whether this was about bonds or claims or whatever, that's not relevant to the appeal. What is relevant is that the only opportunities, these are referred to in the NDA as opportunities with a capital O, were these publicly known, even on the judge's definition, bonds. They were the ones that were brought, and and the only things that were brought to the party by IX. And so that range of opportunities with capital O, all of which were to be distressed, could have been debts, private claims, such as non-performing receivables against government entities, and so on. So that's what IX was going to bring. Altana was going to provide expertise in fund structure and management, the regulatory setup, fundraising, and its own sort of successful track record. And you can see that, although we'll do the NDA mostly from what's referred to in the judgment, it's important to look at the joint venture document that was entered into. And so that's at tab 10 at the core. You can see the purpose of the JV. So tab 10, this is page 143 within the bundle. It's in the form of a letter from Altana. Celestino and Galina are the individuals who run IX. We've enjoyed exploring with the opportunity to create a joint funding vehicle to pursue distressed investing opportunities in Venezuela and are excited to move forward to the next phase of implementation. We think of this venture with you as a true partnership in which each side contributes on the basis of its strength and skill, but which both parties help on all issues, if appropriate. And so, in point 2 of the next steps, as you see, agree and sign an NDA, subject of this case. 2, conduct the necessary due diligence with you presenting details of the current 30 million trade, SPV, and other potential trades, and access to DD reports, due diligence reports, and your research team, including review of your legal analysis and recovery strategy. So what the aim was that once the JV was set up, specific opportunities would be brought. Why I emphasize this is because the terms of the NDA, we say, are really to do with protecting business opportunities. However, confidential information within those, opportunities for capital O, confidential information within the NDA is far more broadly defined. And that is why, I'll come on to it, we say the exclusions from the NDA must also be broadly defined. And also it was always contemplated at point 3 that there should be a short teaser presentation that can be shared with potential investors in the initial marketing phase. So they were going to be able to tell people about this thing. And again, a submission I'll be making is it's not sensible to consider that what they were telling people was itself, at the level they were telling them, confidential. And then at the base of the page, to summarise the status quo strengths and future activities of each side, AW, that's Altana Wealth, fundraising and fund management, infrastructure, investment advisory, portfolio construction, so the nuts and bolts of how you put together a portfolio, and then CG, which is IX, sourcing of assets for investment, screening, managing and monetizing the assets, advisory to fund fundraising. So, for the purposes of the JV, Altana, Brevent and IX then entered into the NDA and non-circumvent as the subject of this dispute. As I've said, and as we'll see, within that NDA there is a very broad definition of confidential information to be protected that goes far beyond specific opportunities with a capital O. But there are also a range of carve-outs and a clause to the NDA and a clause allowing the parties to compete on specific terms if the NDA didn't go ahead. And we say, crucially, it was contemplated between the parties, from this context, that the parties to the NDA would not be in any worse position than any third party if the joint venture did not go forward. So when you're looking at the carve-outs, the key thing is third parties and what's known, what comes from third parties, rather than drilling down into the rights between the parties here. And we say it was contemplated that they would be free to compete other than, parties, if the JV didn't go forward, would be free to compete other than in respect of specific capital O opportunities which remained confidential. As it turned out, the JV did not proceed. IX brought it to an end in November 2019. As I've said, no opportunities were ever provided by IX other than a list of bonds that could be traded in without engaging the US sanctions. Bonds that the judge rightly identified as being in the public domain even on his definition of the term, as was the fact that they could be so traded in by non-US entities without breaching the sanctions. So after the JV ended, Altana decided to continue to set up its fund to invest in distressed Venezuelan debt, and it did so using only those publicly traded non-confidential bonds. It kept IX informed as to its plans and invited IX to participate in the proposed fund on the previously agreed terms. IX declined. No objection was raised by IX until just before the launch of the fund, when further rounds of marketing materials were sent out in May 2019. And indeed, IX had kept in contact with AW and offered to supply non-confidential bonds to the new fund. So the issue at the centre of this appeal is the identity of the protected confidential information in issue. What it is, in particular, with regard to the so-called business opportunity, capital B, capital O, relied on by my learned friend, and whether that confidential information is excluded from protection by a carve-out, whether on the basis of it being in the public domain or on the basis that it was already in the defendant's possession or was received from third parties. Those are the carve-outs that are covered by the NDA. Now, the way in which Illiquidx pursued its claim has a checkered history. The way it defined its confidential information shifted throughout the 4 years that the case took to get to trial, and continued to do so through trial until my learned friend landed on the final definition of business opportunity that he relied on in his closing. Now, my clients consider that there was significant unfairness to them in the way in which the case developed, although the final definition was open to IX on the pleading. It was not how they'd advanced their case until then, and marked a very significant change in focus in the closing. Now, we're not saying that they weren't entitled to do that. We're not saying the judge was wrong in allowing them to do that, but we say this is how it goes, and we'll see the way in which the case was fought up until closing was really focused on bits of detail, and this high-level business opportunity is something that my learned friend was driven to by what came out in cross-examination and how the evidence developed. So by closing, that's the business opportunity, which was relied on by IX. The other matter that's relied on by IX is called the detail. Now, the detail, as pleaded, is a vast raft of individual items of information buried in long documents and mixed in with things that weren't confidential. The detail was relied on alone and in combination, but even there, the information relied on shifted through the case, and as the judge records, the emphasis given to the detail was not great at trial, notwithstanding that I spent quite a bit of time in cross-examination addressing the detail. By closing, as the judge records, IX only relied on the business opportunity, capital B, capital O, at a very high level of generality indeed. And that is what my learned friend said in closing. It was the opportunity to set up a sanctions-compliant fund to exploit undervalued Venezuelan debt. No more detail in it than that. Not a strategy by which that was to be achieved, not a specific custodian for use in that opportunity, not any single investment opportunity as part of that business opportunity BO. And we say my learned friend was driven to that because of how the evidence developed. The judgment then principally focused on that business opportunity, which is also the focus of this appeal. Limited aspects of the detail are also held to be misused, but as I'll show you, apart from a few very limited points, the only nature of the use is really as part of this broad business opportunity. Now, why I'm banging on about this is because in due course I'll show you that in my learned friend's appeal skeleton, even now, there's a dispute on the scope of the business opportunity. We say IX is up to what we call its old tricks from trial in attempting to expand the business opportunity to include detail so as to strengthen its case. We say they need to do that now because of the level of generality of the business opportunity relied on in closing, it was in the public domain or subject to other carve-outs, even on the judge's construction. So in order to show you why my learned friend is not entitled to do that, I'm going to unfortunately have to show you some of the history of this shifting case by reference to bits of the pleadings and the judgment. And why we say that is important is because in limiting the business opportunity to what was relied on at trial, my learned friend abandoned significant parts of the pleaded case as to what the business opportunity BO was, which he now seeks to resurrect on appeal. And we say it would be unfair for him to be allowed to resile from that general definition of business opportunity on this appeal. And it's also my client's case, to put this in context, that IX's changes in position are what really led to the judge falling into error and internal inconsistency in his decision in respect of the business opportunity and whether it was in the public domain. And crucially, what we say about that, I mean, to give a flavour, the judge held that every single opportunity with a capital O that my clients have traded in and that were the subject of this potential fund, the only things that IX brought to the fund were these bonds that were available and known about in the public domain as the judge held. And so we were allowed to trade, those things were not confidential, and yet by having this high level definition of business opportunity relied on by my learned friends, he held that we had misused that concept. We say it cannot be right that in the light of the fact that those individual opportunities were known, and as the judge himself records, that there was at least one other fund out there trading in distressed Venezuelan debt at the relevant time, and that's the Copernico fund. I'll show you where in the judgment where he gets that. And in light of that, we say it cannot be correct that the business opportunity remains protected. So, we say on this appeal, the judge erred in his approach to how he got to this error is he erred in his approach to the exclusions from the obligations under the NDA, which we call the carve-outs. In particular, in relation to the definition and application of the public domain carve-out, which is the matters that are in the public domain under, it'll be clause 1.1a and b of the NDA, were no longer to be protected. So there's an issue of construction as to the meaning of public domain, but also his application of that construction on his own construction and on, we say, what should have been the right construction. But we also say he failed to take into account at all the other carve-outs which concern material obtained from third parties or material that was already in my client's possession. And we say the judge's construction of public domain rendered the NDA commercially impractical and internally inconsistent. So the first point on appeal is a matter of contractual interpretation as to the scope of the NDA and the carve-out for public domain. The second point on appeal concerns, is our allegation the judge was wrong in finding that the business opportunity and detail were protected under the NDA at the time of misuse by reason of the carve-outs. And that's both the public domain carve-outs and these acquisition from third-party carve-outs. And that second point will require consideration of some of the evidence that was before the judge, but it's either documentary evidence or witness statements that don't take much to look at. Not a vast amount. We do not challenge any findings in relation to the credibility of the witnesses.
May I just ask an administrative question?
My lord, yes.
Is
please.
there a transcript being made?
There is a transcript. I'm sorry to say it's not a live note, but there is a transcript.
There is one, and that will be made available to the court.
My lord, yes, and that reminds me, I should have said, normally when there's a transcript, we give them a break because of me gabbling on.
Well, I'm afraid to say we don't normally give breaks in this court, and we appreciate the labours of the transcribers, but there it is.
My lord, then I won't suggest that we have one, but I will try to moderate the speed of my submissions so I don't make them too tight. So the third ground of appeal before your lordships concerns trade secrets. Now this is essentially parasitic. I think it's common ground between the parties and shouldn't take up much time at all. Why we challenge the judge's approach on finding that
I'm
trade
not sure
secrets.
why it should take up any time at all, given it seems to be common ground that it stands or falls with the contractual claim.
My lord, that's certainly my position. I don't intend to address you further in light of that indication. It wasn't entirely clear to me that there was whether there was anything more that came in on my learned friend's point. And there was a fourth ground of appeal for which no permission to appeal was given. That's not pursued. So that was in relation to a specific finding in relation to Mr. Robinson. So, with that somewhat lengthy introduction, may I take your lordships to the judge? Tab 7 within the court bundle. So the starting point, we'll look at some introductory matters and then move on, but behind tab 7 on page 93, the start, paragraph 6 on page 93, the judge identifies that although equitable duties of confidentiality are pleaded, the primary issue is whether there's been a breach of contract, and he refers to, at the end of that paragraph, an important carve-out in the NDA which has the effect that the information which is in the public domain cannot be protected as confidential information under the NDA. That is, of course, correct, but we do say it's notable that he doesn't mention the other two carve-outs that were relevant when we come to them. Paragraph 7, he defines IX's pleaded case. This is not what they ran at a trial or by closing, but it is setting out the pleading. So the pleaded case is that it presented the defendants with a package of confidential information called the business opportunity, and it sets out here that is essentially taken from the pleading, the business opportunity that there were distressed Venezuelan credit opportunities which the market had ignored and or avoided and or undervalued because of international sanctions. And then crucially, we say, when you get to the second half of that sentence, says, but that such credit opportunities could, upon application of IX's investment strategy, be monetized and exploited for value notwithstanding those sanctions restrictions. By the time we get to the business opportunity relied on, there is no hint of investment strategy. And no hint of how matters were to be monetized or exploited for value notwithstanding those sanctions. It's just the business opportunity as defined. And then the final part of that paragraph, the business opportunity is also alleged to be itself confidential information, whether or not any part of the package of information which it comprises, which it calls the detail, is confidential. So how this was pleaded was, and I believe, my Lord Justice Miles, you had access, you received contact with this during the strikeout application. You heard it on appeal, and the detail at that point survived. But what was referred to as the big idea didn't. The business opportunity came back, sort of the big idea in a hat, and then changed as we went through trial. So at 8, the defendants say IX's pleading failed to identify with sufficient precision the business opportunity or its constituent parts so that it can be protectable. They also say there's nothing in the business opportunity or the detail which they can be proven to be used, which was not already known to them or on the public domain. So that's the two different carve-outs that creep back in here. In this regard, the defendants rely on the fact that IX itself, and IX and the defendants during the JV, publicised the business opportunity in substantially all of the detail by circulating promotional materials to potential investors. And then he says the effect of that publication is an important issue. Trade secrets, nothing turns on it. Copyright, there was an allegation that by providing marketing materials, they infringed copyright. That failed. And then 12, joint liability. In respect of any wrong it establishes, IX claims that Mr. Robinson and Mr. Castor are also personally liable as accessories. In light of pragmatic concessions made by the defendants, the principal issue here is whether Mr. Kastner is jointly responsible for the wrongs committed by Altana, Brevent or Mr. Robinson. But as we'll see, there are findings made at paragraph 130 of the judgment which make clear that neither Mr. Robinson nor Mr. Kastner knew that the materials, in particular the business opportunity that they were alleged to have misused, was confidential, which is, in my submission, it should ring an alarm bell when you're dealing with a business of a supposedly confidential concept at such a high level of generality that the only thinking minds of the defendant companies didn't know that it was confidential. It says something. Paragraph 13 onwards addresses the trial and the evidence of the witnesses. I don't propose to take you through it. And indeed, I don't propose you, at this stage, to take you to the treatment of the NDA, which is at paragraph 68 to 82. I'll come back to that. But I do want to just show you the treatment by the judge of the IX's pleaded case, which starts at paragraph 83 on page 111. So, 83. The judge sets out the need for particularity, all motherhood and apple pie, absolutely correct, and records that IX has struggled to address its case with particularity. Its pleadings have been amended and reformulated several times, have been the subject of correspondence, requests for further information, and ultimately court decisions. And 84, the judge introduces what's referred to as RACA 1, which is re-amended Confidential Annex 1 to its particulars of claim, which sets out the confidential information relied on. And he says at second sentence of 84, the present shape of RACA 1 is that the first half, from A1 to A12, describes a package of confidential information called the business opportunity, capital B, capital O, while the second half sets out what is referred to as the detail. I ruled at the pre-trial review that the pleaded case is that the business opportunity is composed of the information listed in the detail. The detail comprises documents and is limited to the passages in the documents which are identified in the pleading. What happened at the pre-trial review is there was an attempt to broaden the business opportunity to matters that might have been said orally, things that were not identified in the detail. That did not succeed. Then at 85, and we'll look at RACA 1 shortly, I'm sorry to say, but 85, definition of the business opportunity. According to RACA 1, the business opportunity was that there were distressed Venezuelan credit opportunities, namely the opportunities defined in the NDA with the capital O, which the market, including the defendants, had ignored and or avoided and or undervalued because of the OFAC sanctions restrictions on Venezuela, but that such credit opportunities could, upon application of IX's investment strategy, be monetized and exploited for value, notwithstanding the aforesaid sanctions restrictions. And then within the pleading, you'll see there's a whole raft of matters said to comprise IX's investment strategy. Then at 86, although paragraphs A2 to A11 of RACA 1 appear to set out other elements of IX's investment strategy, Mr. Green, in his closing submission, sought to focus on the idea of a sanctions-compliant fund. So this is the identification of the business opportunity that was the subject of the trial. The business opportunity, he submitted, was the opportunity to set up a sanctions-compliant fund to exploit undervalued Venezuelan debt. And then the judge said this was valuable because it was not common knowledge in the market that this could be done, and IX had the know-how to overcome the apparent obstacles in the way. I accept this change of emphasis within IX's pleaded case, and Mr. Moody Stewart did not seek to argue otherwise. This is because a sanctions-compliant fund as a means of unlocking value is described as part of the package of information concerning the business opportunity and confidential in its own right. And then he refers to A33, A63, and A12. So there's a specific point within RACA 1 which refer to such a fund. Okay. Now, and at 88, just before we go to 87, he addresses the detail. And then 88, the business opportunity was the focus of Mr. Green's submissions at trial. Little time was spent on the detail. In this judgment, I too will focus on the business opportunity. I have set out my findings in respect of each element of the detail in the schedule to the judgment. So the schedule, which starts at page 124, goes through each of the heads of the detail, and some were not confidential, some were confidential and misused. Now, I'm going to take you to the pleadings and just show you what was abandoned when Mr. Green limited his case, and why one needs to read the judgment with that in mind. The re-amended particulars of claim is at tab 13. And on the first page, 1A, there's a summary. So the green is, those are the amendments that flowed following the appeal in front of my Lord Justice Martin. So here there's a reference to 1A, as set out below, in the period between 5th of April and about the beginning of November 2019, the claimant communicated to the defendants a package of confidential information, the claimant's confidential information, identified in paragraph 19 below. We then turn to paragraph 19, which is on page 169. This defines confidential information, and 19A says re-amended confidential Annex 1 identifies the claimant's confidential information on which the claimant relies in these proceedings. So that's RACA 1, and we can find that behind tab 16. So page 185 of the bundle. Now, the business opportunity is the heading, and it's set at 1 to be a package of information. And then at A1, you can see that full text which the judge set out in his, in the paragraph in his judgment when he was dealing with the business opportunity. And you can see within that pleaded case was the specific reference to application of the claimant's investment strategy, as explained below, and the fact that it could be monetized and exploited for value notwithstanding the aforesaid sanctions. A3 then refers to the consequence of the business opportunity having been given to my clients. The claimant gave the defendants a special insight into the monetization of distressed Venezuelan credit opportunities, which enable my clients to see for themselves the hidden value in such credit opportunities. But again, we say that is a consequence of the disclosure of the business opportunity, not the business opportunity itself. But within that, you see at A33, this is something the judge referred to in particular. A33, the claimant showed the defendants how, by the use of its investment strategy set out below, including the use of an OFAC sanctioned compliant fund, the value of the distressed Venezuelan credit opportunities could be unlocked. So what my learned friend landed on was the use of a sanction compliant fund. What he did not pursue were all of the other matters that are relied on in terms of investment strategy. And that's why it's important that he's not allowed to seek to bring in extra bits of detail referred to by him as things such as the rationale behind investments and so on and so forth. Heading, just leafing through, we see here at A4, once it is the particulars, and it is slightly surprising to see these called as particulars, but the particulars of the business opportunity which made up the claimant's investment strategy and which in combination gave rise to the business opportunity are set out below. So this is from A4, you see that, and then at A5 you see these said to be the particulars. Again, this is far more detail and far more matters in here than were ever eventually relied on by my learned friend when he restricted himself to the business opportunity as defined in closing. And but just looking at the things that the judge, so let's go through some of them. You have 2, identification of the distressed Venezuelan credit opportunities. That given the Venezuelan credit opportunities relied on, and the only ones used were held by the judge to be in the public domain, could not have been part of a protectable business opportunity if it was confidential. So that is something that gives some indication for why my learned friend stepped backwards and didn't refer to investment opportunities as being part of the business opportunity. It was just the idea of going for any form of investment opportunity. But under A6(3), this is another point the judge referred to on page 189, the claimant explained that the business opportunity was to be realised through an OFAC sanctions compliant fund. So that's the point, investing distressed debt through a fund. But then we see under 3, the heading use of risk strategies to trade and settle distressed Venezuelan credit opportunities. None of that survived as part of the business opportunity. None of that was disclosed as coming to my clients. Strategies to exploit, 4 strategies to exploit features of distressed Venezuelan credit opportunities. Again, not relied on as part of the business opportunity, capital B, capital O, and that includes within it, if we look at page 8, prescription, fiscal agency trustee structures on page 193. All of these matters of the detail, litigation strategies on 195. These were not part of the business opportunity. If they're anything, they're in the detail, but they're not part of the business opportunity, which is this extraordinarily general point. And then at, 5, enforcement recovery strategies, 6, selection of custodian. Again, just to reveal why my learned friend limited himself in this way, it was alleged and hotly disputed at trial that the identification of a custodian was an important part of the package of confidential information that was provided and an important part of the business opportunity. It turned out it was my clients that found the custodian. And that you could see that from the schedule of detail. That's what the judge held. And so my learned friend couldn't rely on selection of custodian as part of the business opportunity, and so he retracted to this very general proposition. And you see that at A11. What's said is the defendants did not know of any such custodian. Identification and use of an appropriate custodian was essential to the realisation of the business opportunity. So it was important, but it came from my clients. And then heading, as indeed the judge held. And then at 7, the heading use of an OFAC sanctions compliant fund, the judge referred to A12, not the subparagraphs to it, and he says the implementation of the business opportunity was to be effected through a special OFAC sanctions compliant investment vehicle designed and developed by the claimant, namely the Canaima Fund, which prototype structure the claimant provided to the defendants in confidence. Now, the business opportunity as defined does not include that prototype structure. It's just investing via a fund. And it's important that my learned friend is not allowed to bring in a particular structure, prototype structure, or anything else to bolster his business opportunity, because when you look at that level of generality, which is what he advanced before the judge and how the judge dealt with this at trial, it's against that we must test what was in the public domain and how the NDA functions. So, A13, before we move on, A13 introduces the detail. A13, as stated above, the business opportunity was a package of confidential information. It was made up of component pieces of confidential information contained in and or evidenced by the documents or other communications that the claimant provided to the defendants. In circumstances giving rise to the obligation of confidence, these component pieces of information, the detail, are set out below. And then at A14, for the avoidance of doubt, the claimant avers that the business opportunity as a whole is confidential regardless of whether any component piece is or is not confidential. So they were saying even if bits of the detail were not confidential, the business opportunity could still be confidential. And then at 199, the claimant's case is that each document and legal advice is itself confidential without prejudice to the foregoing. The claimant identifies within the documents and legal advice the specific passages or parts of the document's legal advice on which it relies as confidential and confirms it does not rely on any passage not so specified. And then behind that, at page 16, internally 200 of the bundle, you have this list of documents, and then this vast raft in red with splashes of green of what was said to be the detail. A very significant number of documents, some 510 pages or so. And in my submission, it was truly impossible for the judge to decide the case in the form pleaded, and the judge did not attempt to do so in the light of Mr. Green's reformulation of the case in closing. The judge made no findings on the use of the investment strategy referred to in the pleading as part of the business opportunity, or the use as part of the business opportunity of a business rationale, though certain aspects that were said to be part of the strategy were indeed held not to be protected, such as the custodian. So in my submission, the judge relied on IX's change in position, held that they were entitled to do that based on their pleaded case, we didn't challenge that, and then decided the case on that basis. And that's clear, and his reliance is clear not only from the judgment, you can see his express approach in the judgment, but also the narrative in the costs judgment. And I'll show you this in just a few paragraphs, but I just need to show you this, because it was, in my submission, quite extraordinary. In the supplementary bundle at tab 45, this was the judge's judgment on costs, and at 256, starting paragraph 14, he addresses IX's conduct. Now, why this is relevant is not for me to say IX behaved badly. It's to say that it shows the judge relied on this change in behaviour when approaching the issues in the judgment. And it's simply wrong from a learned friend to seek to import matters of the detail back into the business opportunity. So he records the history.
Which bundle and which page?
Sorry, we're at, beg your pardon, Arnold. Supplementary bundle
I've got the wrong
at tab 45 on page 256. So at paragraph 14, he points out the the claimant, IX's inability to refuse or refusal to supply with any clarity or precision what its case was as to the confidential information it says was misused. Records that we've tried to clarify it. And then at 15 it records the strikeout, and then the appeal from that strikeout heard by my Lord, Lord Justice Miles, which removed the big idea as they pleaded it and held them to the detail, but did not rule out the possibility of reformulating. And at 16 there's recording how the new draft was produced. And then at 17, he records what went on at the pre-trial review. But it's the crucial points are in my submission 18 and 19. 18, in IX's trial skeleton argument, continued the same expansive approach, making extensive reference to the detail as well as reliance on matters not in the detail. It also abandoned a claim for injunctive relief, which might have meant that ACOF had to cease operating, having obtusely refused requests to do so and having resisted an application to strike out that relief a few months earlier. A significant part of the defendant's skeleton argument was devoted to trying to make sense of IX's pleading. Mr. Moody Stewart fairly described the business opportunity pleaded as hopelessly vague. So that's the as pleaded, not as focused in on. Mr. Moody Stewart duly cross-examined IX's witnesses about all the documents in the detail and addressed the case he thought IX was advancing. It now appears, to use his words, he was fighting yesterday's war. Well, indeed. For in his closing submissions, Mr. Green dropped substantially all the detail without formally abandoning IX's case on the detail, and argued that the business opportunity was the high-level idea of a sanctions-compliant fund, which was evidenced by a few documents in the detail. In the liability judgment, page 3 to 88, I concluded this change of position was within IX's vague and expansive pleading case. Mr. Moody Stewart did not seek to argue otherwise. Well, it is within that pleading case. We say that the change adopted by Mr. Green in closing had a material effect on the case that was being advanced and a material effect on the judge's decision. And Mr. Green cannot now seek to reintroduce detail to the business opportunity that he abandoned for the purposes of trying to get home at trial. And we say that's exactly what he's now trying to do, as you will see in parts of his appeal skeleton. I'll show you as we go past. Before we leave the pleadings, just as a matter of form, I just want to show you the defence where we address the business opportunity in its original form and refer to something that was said by IX's then counsel, not Mr. Green, at the appeal hearing for my Lord or Justice Miles. So this is at tab 18 of the core bundle, the re-amended defence. And if one turns up, I can take you to paragraph 6b, which is on page 248. So this comes from the passage 6a and 6b, where we're addressing their paragraph 1a, the assertion of the general case. And here we said at 6b, at the appeal hearing before Miles J on the 14th of January 2022, the claimant's leading counsel, Mr. Salter, QC, put the claimant's position as follows. And then we rely in particular on the part underlined, where he was trying at that point, in front of my Lord Justice Miles, to address his big idea. Okay? My Lord, if all we had done was say, is not Venezuela a great idea? That was public knowledge. I showed your Lordship Venezuela being the investment opportunity of the year. The point is, this great opportunity was one that was not being exploited because people did not know how. You needed a way of unlocking the value in the opportunity. And that is what my clients say they provided. Part of that, the first step is saying it is a valuable opportunity. But the vital second step is, and we have a way of unlocking the value in that opportunity, which no one else in the market has, and which you do not have, and which we will give to you on the terms of the NDA for the purpose of a joint venture between us, which will provide that expertise, and you, established fund managers, will provide fund management platform and all the other marketing stuff. Why I show you that is because the effect of the reformulation of the business opportunity is that there's no reference to this investment strategy or how, particularly in the face of that, the how, the second part of Mr. Salter's analysis. Where the how comes from is because the specific bonds that we traded in and that were brought to the joint venture by IX were inherently capable of being traded in, full stop, because they were excluded from sanctions for non-US investors. And the judge held that the identity of those bonds and the fact that they could be traded in was known. So they're not protected as part of the detail. So the business opportunity, this is where we say, and it's perhaps unsurprising that a judge might fall into error in this way, given the melange submissions in front of him below and how the case had shifted. But we say this is a fundamental flaw on whoever's construction of public domain, that the judge himself held that all of the investment opportunities, capital O, that my clients dealt in, were in the public domain, and it was known they could be traded in without falling foul of sanctions. And what are you left with if that is in the public domain when one looks at the business opportunity? It's just, isn't Venezuela distressed debt a jolly good idea? It can't be confidential, we say, to deal with it in a fund, because that's what my clients do. And a fund is just another way of investing.
The confidential annex does appear to be the how from that dichotomy in Mr. Salter's submissions.
Yes.
But your submission is that Mr. Green abandoned the entirety of the how.
Yes, my lord.
At trial.
He ditched it all because significant parts of it were, we brought some of them along, they didn't bring them. So the identification of a custodian. There had been cross-examination as to what was confidential and what wasn't confidential and what had been disclosed. And so when my learned friend defined the business opportunity that he was running at trial as the opportunity to set up a sanctions-compliant fund to exploit undervalued Venezuelan debt, That's what he's got. The detail was something that was addressed in the schedule. The detail, the component parts, if he'd been importing those and saying it's just a combination of all of those, he wouldn't have needed to change his case.
So one, just homing in on one example of the detail. One of the things in the judgment schedule,
Yes.
in the annex, is the fact they took advice on prescription from a particular professor, I think.
Yes.
And that was part of the strategy, was to get in early enough because people hadn't realised that. Now, leaving aside whether that's confidential or not, but it's found to be confidential information.
Yes.
Why did the judge deal with that at all? It's simply irrelevant, isn't it, on your high level analysis? That has no relevance whatsoever.
Well, my lord, it does, because there's a piece of detail. If it turned out that detail, that precise bit of advice that he is, because the evidence as the judge had in front of him and held was that there had been, they'd sent from their own website an email identifying prescription clause. But the evidence of the legal advice, which he held was confidential, was prepared and paid for by the judge.
And was misused, I think you found.
That was misused. If that turns out to be something that stands and is misused, that doesn't protect the business opportunity at large. That protects that piece of detail. And the value of that, if it comes to an inquiry as to damages, is the value of getting that, well, we can argue about what flowed from it. But the business opportunity at large is as distinct from the individual bits of detail that are relied on. We say this is crucial when it comes to quantifying, if anything survives, quantifying the financial relief.
All right, well, that's an important point, which, speaking for myself, I don't think I'd appreciated from the skeleton arguments. And that may well be my fault for insufficiently closely reading. But to be clear, as I understand from what you've just said, you are not challenging the judge's findings in respect of specific items of detail. It is the finding in respect of the business opportunity that you challenge. Do I have it correctly?
My lord, mostly is what I would say. There are a couple of specific points of detail in our plea that we say on the documents form the judge just didn't get right. And if we were right that the disclosure, if public domain meant that the sending out of the marketing materials, which contain all of the detail within them, was enough to put them into the public domain, then that would also carry with it the points of detail. But what we're really concerned with is that high-level business opportunity, because that is what is going to be relied on in terms of financial relief by my learned friends to say, well, we should never have started the fund.
Okay, so what I suggested to you is not correct.
It's
in
not.
fact, you do challenge all the findings, but perhaps some on more than one basis.
Yes, that's it. So there's, and if we're wrong about public domain, then obviously, and the judge, because when we come on to public domain, there is an issue as to, if one's looking at the business opportunity defined at that high level of generality, because the term, even on the judge's construction, the term public domain is somewhat context dependent, one might say. At that high level of generality, we say that can't have been protected, although specific points might have been viewed as being protected. So, my lord, there is a material difference, we say, between a finding that we misused the business opportunity as defined by my learned friend and the relief that might flow from that, and a finding that there are certain aspects of the detail, so the judge didn't hold that we misused all of the detail, certain aspects of the detail survive that then you look at the financial relief in relation to that flows from such misuse, if that were. There are specific points of challenging the detail in relation to, for example, the multi-cell structure, which we say is something that was known to my clients. The use of a multi-cell structure is absolutely old as the hills and was previously known to my clients. So that's one bit of detail that we do challenge, but that's a specific point on the carve-outs that I'll get to under once I've dealt with construction. back to the judgment, if I may. So we looked at, so this is...
I just wonder whether you might be able to produce a forensic document just to assist on the points just being made. On the points of detail, whether you can just produce a document by reference to your skeleton argument on this appeal, saying where, if anywhere, there's still a challenge to the points of detail on the basis of one of what you call the carve-outs.
Certainly not. Certainly not. And that's... You've asked for a document, so I'll do it in a document rather than do it on my feet.
Yeah.
But there, within the skeleton argument, we do address the carve-outs, in particular the carve-outs where we say my clients knew about it already. So the multi-cell structure is a particular one. But I will flag those.
Yes, but the key point that you're making, as I understand it, is that even if you fail on some of the points of detail,
Yes.
you are saying that you can still succeed on the business opportunity.
My Lord, most certainly. And it matters to us. It matters to us because of the difference between the business opportunities drawn so broadly that it might be said the misuse of that leads, the misuse of that, if you weren't misusing it, you couldn't set up a fund at all. Yeah? Whereas we say, if you're talking about just bits of detail, then it might be a different way of looking at it is to say those particular bits of detail, look at the value of the individual detail. So Mr. Olivares, Professor Olivares Cabanal, was paid for his advice. And he distilled it in one particular form. And so if we lose on that and that alone, then it might be said it's the value of the advice. But this is the vice in the business opportunity at this large level of generality being then used as what my learned friend seeks relief in relation to. So, my lords, back to the main judgment. We've looked at paragraph 86, which was where the judge addressed the pleading. Sorry, was talking about the pleadings and the elements of IX's investment strategy, and at 88, where he addresses the focus of business opportunity. So, just to be clear, our position is that the business opportunity is only that defined by Mr. Green in closing. It is the opportunity to set up sanctions-compliant fund to exploit undervalued Venezuelan debt. It is not a collocation of all and any parts of the detail. That business opportunity, as Malone Friend defined it in closing, recorded by the judge, was what the judge decided the case on. And in respect of my client's activities, the only thing that rendered our trade in the bonds that were public domain were the fact that they themselves were excluded from sanctions. There was no special magic disclosed, no information provided other than that. And the judge held that those bonds were known to be capable of being traded in a sanctions-compliant fashion. So, and indeed, when we look at how, so the judge at 90 addresses whether IX can identify confidential information given to defendants, the business opportunity, the opportunity to set up a sanctions-compliant fund to exploit undervalued debt, so again he's using those words, is confidential information as defined in the NDA because it was IX's idea and concept and therefore was information relating to Illiquidx for the purposes of subparagraph B of the confidential information and was also within subparagraph 2 of the definition of Illiquidx, its intellectual property. And so that's how it was protected. It was protected within the very broad definition of confidential information. It was not protected in the sense of being one of the specific opportunities that were provided by IX to the fund, which was only those bonds.
But to be clear, you don't challenge the finding in paragraph 90.
No, we don't. No, we don't. And then 91, while we're here, this is something my learned friend relies on, in an attempt to expand the business opportunity. 91 says, the details of the business opportunity, such as IX's idea of creating such a fund, the rationale for it, IX's proposed structure of the proposed fund, including the use of a multi-sell strategy, provision for contributions to be made in kind, and provisions for dealing with the inherent illiquidity of such a fund, were contained in a number of documents provided to the defendants which are pleaded in the detail. So that is not saying the business opportunity comprises all of those bits of detail form part of the business opportunity. He's there identifying that there's a second strand of stuff that is of more detail, there's so many ways we can address it, than the general idea in the business opportunity. And those are the ones that are within the detail. And that's what he refers to as the fund detail, capital F, capital T. So, now just look at how the judge then dealt with this. This is an important part, we say, of the judge's approach. We say reveals the inconsistency of it. But paragraph 95, I'll address you later on how public domain is addressed. But at 95, the judge said, the fact that Venezuelan debt was distressed and Venezuela had defaulted on most of its debt was well known in the market. The fact that it could be traded in, notwithstanding the US sanctions, was known amongst some specialist investors, but not widely known. The business opportunity, the opportunity to set up a sanctions-compliant fund to exploit the undervalued Venezuelan debt, was not widely known in the market. So again, he's saying it's not widely known, it's known. The defendants say that the business opportunity was staggeringly basic, but I do not consider that it was. It seems to me that very few people knew that setting up a sanction-compliant fund to trade in Venezuelan debt was possible. Even now, apart from ACOF and IX's own post-JV fund, parties have only been able to identify one other fund which was established. That's the Copernico Recovery Fund. Now, that's the defendants, IX's evidence was that Copernico Recovery Fund was in operation at 2019. So at the relevant date, the fund was out there trading.
So this seems to assume that how you set up that compliant fund is part of the business opportunity.
My lord, no. The business opportunity is as it's defined. I think that the judge had, at this stage, he had failed to grasp, because of the shifting case, he failed to grasp that once the bonds were in the public domain, as he holds himself, he says here the bonds, here he says the bonds, the fact that it could be traded in, notwithstanding US sanctions, was known among some special investors but not widely known. So there, he's saying there that the bonds were known but not widely known. But if you look at his detail, at page 125, B1 of the detail, this is an email sent that included every single one of the bonds that were dealt with. Is it IX's, so this is on 125, B1, heading in the table, is it IX's confidential information as defined in the NDA? Yes, confidential information. It identified the bonds. This was information relating to opportunities, capital O. Is it permitted disclosure? Yes. The 38 bonds which could be traded despite sanctions was information which was publicly available. The list of bonds was downloaded by Mr. Robinson on the 10th of September 29 from the OFAC website where it was accessible to anyone. So he just...
So that's that's the second sentence. The fact that they could be traded was not widely known. That's that issue. My question was the next sentence. The opportunity to set up a sanctions-compliant fund to exploit undervalued Venezuelan debt. My question was whether there's implicit within that, not just the idea to do it, but the opportunity to do so imports how you would do it. In order to say that there's an opportunity to do it, you need to explain how that would happen. So doesn't the how you do it built into that concept of business opportunity?
Well, my lord, but the only how that was ever provided, and the judge holds this, the only opportunity was these bonds that were in the public.
So there's nothing more to how than saying, there they are.
Well, these bonds could be traded in a sanction-compliant way as long as you weren't a US citizen. And if you found a custodian, which we've ourselves found a custodian. So that opportunity to trade, my own friend went so high level on his business opportunity that there's nothing in there that is protectable in light of what the judge himself found in terms of what was disclosed by way of the, and not protectable by way of the detail. So, and you might say, well, it's a peculiar finding to make, but bear in mind the shifting nature of Malone and Friends case and what had gone on. And that's, to be clear, this is on the judge's definition of public domain, which is it's not enough that it be known, it must be widely known, he was saying. But even on that, there's an inconsistency here, because you can see, he says, the fact that it could be traded was known, but not widely known. In the detail, he says it was widely known. I mean, it's on the US government website. So again, these are inconsistencies, we say, resulting from the shifting nature of Malone and Friends case. Now, just to be clear, Malone and Friend, to meet the skeleton we set out, the case we set out in our appeal skeleton, Malone and Friend now seeks to contend that the business opportunity was in fact still protected by resurrecting his collocation and package of information case. And in particular, he seeks to meet our case that the business opportunity, as he defined it, in closing, was known or otherwise excluded, by adding back in the specificity to the business opportunity that he had abandoned at trial, as the judge records. And I just want to show you an example of that in his skeleton. So this is a tab 4, paragraph 10, on page 59. So he says, it's no longer disputed that IX provided Altana and Brevent with the opportunity to set up a sanctions-compliant fund to invest in undervalued Venezuelan debt, or 2, the package of information provided was subject to the contractual carve-outs, confidential information, and 3, Altana and Brevent used that information to set up their competing fund. And he refers to, there's a reference to twice the pie of multi-millions. And he says, to escape liability, Altana and Brevent must therefore establish that the entirety of what the judge found they appropriated from IX as a collation or package was either in the public domain or came into their possession independently from a third party. It will not assist them to say certain individual elements, or even all of them, were publicly available, but have not been put together. There are points on the detail there, but in terms of the business opportunity, you don't need all of the bits of the detail. You look at the business opportunity as the judge decided. And that's where Malone Friend gets on 11. He says, the business opportunity that Altana and Brevent appropriated from IX was the opportunity to set up a sanctions-compliant fund to exploit undervalued Venezuelan debt. The appellant's key submission at 6, that at this very high level of generality, the entirety of the business opportunity was in the public domain. That is wrong for 2 reasons. And the first is, it's said to be a simplistic caricature of the information which IX provided, ignoring the judge's elaboration of the elements of which the opportunity to set up a sanctions-compliant fund to exploit undervalued Venezuelan debt was composed, and which were found to have been misused. And so that's Malone and Friend saying, look at these other elements that can come in. I want more detail. And we say that is not appropriate, that's not allowed. If it turns out there's detail that we have misused, then we've misused the detail. But it doesn't extend to allowing the business opportunity, which was plain in our submission in the public domain, being saved by magpie-like, adding little extra bits of detail. So, well, that wasn't in the public domain. And Malone Friend refers to 91, which is the bit I've just shown you about how it's defined. And at 99, the collation of that information to formulate a rationale. The business opportunity is not the rationale. The rationale is not within that. The business opportunity is just as he ran it. There was a pleading which referred to a rationale that he abandoned. So that's why we say those matters. Malone needs to be kept to the cases run at trial.
Can I just take you back to paragraph 91 that the judgment.
My lord, yes.
In the opening words of it.
Yes, details of the business opportunity.
He then goes on to talk about things like the multi-cell strategy and things in those parentheses.
Yes.
Is it your submission that that's just that the focus there is on the word details with a capital D?
Yes. My lord.
Because I think the way it's being argued in that passage we've just seen
Yes,
is that all of those things within the parentheses are parts of the
Business opportunity
as run in closing.
My lord.
That's what I understand.
My lord, I understand it that way as well. Sorry, that's what my learned friend has said. I don't understand the judgment in this way, because what my learned friend had done is limit the business opportunity, cut away large chunks of it, and just run it at that level of very high generality. And then the judge here, it's infelicitous, you might say, but he says details, capital D, of the business opportunity, and then he refers to those, sets out these things, none of which are part of the business opportunity as survived in closing. They may be found within the business opportunity BO as pleaded, but that was then resiled from, as the judge records, and I've shown you that bit in the cost judgment. It was a very significant shift in my learned friend's case, that it wasn't everything in that vast and discursive pleading at the start of RACA 1. It was just a simple phrase. If my learned friend had run this case from the beginning based on that simple phrase, the trial would have taken a very different shape, and in my submission, the judge would not have been led into confusion and error in the way he found himself. So, my lord, I understand the point you make, and I understand that I think you're accurate in saying that's what my learned friend says. But I say that's not what the judgment means. It's not what the judge meant. He doesn't address anywhere, when dealing with the business opportunity, the misuse of any of these bits. Provision for contributions to be made in kind, dealing with inherent liquidity, multi-cell strategy. That's all. That's in the detail only. And we say where the judge makes findings in the schedule in relation to detail, it's about the detail.
Are you proposing to take us to the moment, whether in writing or orally, where this abandonment took place?
Well, my lord, I wasn't, because it's the judge records that this is what happened in actually in my learned friend's wasn't even in his written closing. I think he stood up in oral closing and said, this is how we advance it. And that's what the judge records it in the judgment, and he records it being somewhat cheesed off, I can put it colloquially, with that posting when you get to the cost judgment, because it's a tremendous waste of money and time. And indeed, as I put it then, I had spent the trial fighting the last war. And it then turned out, well, this is where we are. We're looking at business opportunity at this level of generality.
It just, if one's having to say as to parts of the judgment that, well, that's, which appears to point in a different direction, well, that's infelicitous, and we're having to construe the judgment, it might help if we see what the judgment was what the judge is actually referring to when he refers to the abandonment of the case.
My lord, sorry, let me just check to see whether we're in the bundle before we have the trial. Maybe I can think about it over.
And if it's not in the bundle, presumably it's not a point the other side are taking. So,
well, they have put some transcripts in, so I don't know what I think in the supplement. We'll see.
The point you rely upon, as I understand it, the heart of it for your case is 86 of the judgment, because the judge says there at the beginning of that although A2 to A11 appear to set out other elements, etc., Mr. Green focused on the sanctions compliant fund idea.
Yes.
And then the judge refers to the three specific paragraphs.
Which I've showed you.
Which you showed.
And what I didn't do is within that pleading, the first part between A to A13 of RACA 1, there are a vast number of other things which the judge didn't refer to, And it's pretty clear from, I'd say it's absolutely clear from the first sentence of 86, that he recognises Green doing what he did do, which was disclaim, although A2 to A11 of RAC 1 appear to set out other elements of IX's investment strategy, Mr. Green in his closing submission sought to focus on the idea of a sanctions compliant fund. That's what he drilled down to. And that was open to him on the plea because of those parts. But it meant that we then ignore the rest of it. And that's where, so when we're judging what's in the public domain, we do so by reference to that business opportunity as defined at that level of generality.
Well, and indeed, as we discussed earlier, this is what the judge comes back to at 90. The business opportunity, the opportunity to set up a sanctions compliant fund to exploit undervalued debt is confidential information. That's the key finding, which you don't challenge as such, but you say you then bring to bear the exclusion.
My Lord, yes. And also we say that paragraph 91, which we have looked at and focused in on, and my learned friend relies on, must be seen in the context of being preceded by paragraph 90. Paragraph 90, business opportunity. Yeah? Paragraph 91, that's where he's engaging with the detail. He calls it the fund detail. So it's, we say that my learned friend is attempting to do what he did throughout trial and then finally narrowed himself down to. He's trying to bring in as much as possible of the detail to bolster the business opportunity, because the business opportunity, what he tried to call initially the big idea and came back in a hat as business opportunity, is a way that says, allows him to argue that what my clients have done, all of what they've done, is in some way tainted, rather than just specific bits within the schedule of detail. So that's the point. Sorry, Malone Jr. has been... So, there are some transcripts. Malone friend has put in a supplementary one. I may address you after lunch, and then I've had a chance to look at what they are. But they are for your... Behind tab 6 in the further supplementary bundle. I think these record some of the exchanges with the judge as to
Is this what's called the unagreed one?
No, it replaced There's an agreed application.
But it is, I mean, it is found within, you can find it also within there, I think, but there's something called the further supplementary bundle. And behind tab 6 of that, on page 24, at the base, at line 20, there's a question from a judge. Well, perhaps when we come back, we can discuss that a bit more. At the moment, I understand from you that the contention is that the business opportunity is the idea of a fund at the highest level. Yes. But secondarily, if I need to go beyond that, which I say I don't, so his primary case, idea of a sanction-compliant fund. Secondarily, if I need to go beyond that, which I say I don't, but if I need to go beyond that, it's also the investment strategy for the purpose of monetising that. We've identified all the relevant parts of that in paragraph 72 of our opening. So we say he may have been running a fallback, but what the judge decided the case on was that it's a fund, sanction-compliant investment fund.
So can I just ask, does my learned friend now accept that I didn't in fact abandon that case and that I was maintaining as a secondary case the investment strategy, because that will save me some time in responding to him?
I'm saying that I don't accept that he maintained through trial, or the judge decided that the secondary case, and I don't think there are findings there, and my learned friend hasn't challenged the judge's finding as to what the business opportunity was. I'm not sure where this takes us any further. I was referring to those parts my learned friend has put in to make clear that what I say the judge did was is exactly what my learned friend was suggesting he should do as his primary point. Go for this high level business opportunity point, not all the components. And that's what he decided, and that's what my learned friend, he may regret it now, but that's what he is with, we say. So, just wrapping up before we actually get onto the the substance of my appeal when it comes to the points of construction and then the specific points I've identified in terms of how the judge addressed the evidence. Just further within this, the judgment, you can see how misuse is dealt with as at 104, and then we then have trade secrets, nothing turns on it at 108, ignoring the copyright. Sorry, at one point that arises from 104. And so on the face of it, the judge says, there is clear misuse of the business opportunity and the fund detail. I would just rely on that. But when the judge is talking about fund detail, it's the detail. So it's the distinguish here between the business opportunity, as defined by my learned friend, and fund detail, which is detail. Yeah? So he said both were misused. Detail is all in the schedule, and his detailed findings of the fund detail are all in the schedule. But the business opportunity is that high-level point.
The fund details are defined. It's not detail; it's fund detail. That's defined.
But he defines that in 90. Sorry, 91.
That's for documents which contain the detail.
Yeah. That's in there. But he refers to when he's in that paragraph that my learned friend likes, and I say have to be read in a particular way, and so perhaps are less keen on. It's 91. He defines fund detail.
Yeah.
And we say that in 104, sorry, no, I just want to look at the detail. So there are 2 points that it may save time if I deal with these now. If we look at the schedule, which deals with items of the detail and findings on confidentiality, so this is 124 onwards, my learned friend relies in particular on the due diligence note. It's one of the things he says. So the due diligence note was a note of an information of a meeting that was minutes taken by Mr. Kastner. And there are a number of different items in there. We conceded that it was confidential information as defined. We said not to be permitted disclosure in terms of those particular parts in there. And then, yes, misuse. The specific information about the mechanics and feasibility of trades in different asset classes and the potential recovery strategies form part of the business opportunity which the defendants have exploited. That's not the judge saying that those details were part of the business opportunity as defined. It's just when we traded, that involved the misuse of those bits of detail. Okay? And then the final point on the judgment before I get to the substance, starting a substance on construction on the appeal, is paragraph 127, where the judge addresses joint liability on page 122. So the judge follows from my findings above, that Altana and Brevent are liable for breach of the NDA by misusing confidential information setting up the ACOP fund. I explains that Mr. Robinson and Mr. Kastner are personally liable as accessories. Now, as I explained at 128, Mr. Robinson and Altana are prepared to accept their liability as joint in the interest of procedural efficiency. Mr. Kastner does not accept yet any liability in respect of the contractual liability of Brevent under the NDA, but otherwise accepts liability against Brevent and vice versa. Then at 129, the judge engages with the case as to how it's said that IX asserts liability on the part of Mr. Kastner. But at 130, it's the crucial finding we say, IX has not established that Mr. Kastner or Mr. Robinson knew that in establishing ACOP they were using information which was IX's confidential information protected by the NDA. Both Mr. Kastner and Mr. Robinson appear to believe that there was no information provided to them by IX which was proprietary, the phrase they use, and protected by the NDA. They believe that Altana and Brevent were complying with their obligations under the NDA. They did not have the requisite knowledge that they were procuring a breach of the NDA. They were not acting willfully and knowingly in misuse of confidential information. So we say it is telling that the only sort of thinking part, certainly in terms of Brevent, Mr. Kastner is the only director and shareholder. These individuals did not know that what they were doing was misusing confidential information. So that suggests there is something going awry with the judge's approach to the exclusions. And also, insofar as public domain bears its meaning, flexible as it is and uncertain as it is under the law of confidence, as a concept of relative confidentiality, such that as long as there's any value at all left to IX, it's in there, which I think is how my learned friend puts it, that, which is something that's intended to reflect the effect on a receiving party's conscience of the fact there stood some value, this finding reveals the information was not considered confidential by the individual defendants. They didn't think there was any residual value. Right. Ground one, construction of the NDA and the carve-outs. We turn up where the judge starts to address it. This is at tab 68, sorry, page 68 behind tab 7. No, that can't be right. Paragraph 68, page 107 behind tab 7. Now, there is no dispute, I don't think, between the parties of the general approach, correct approach to contractual interpretation. We rely in particular on the iterative approach emphasised in Sarah and Hussain Asset Holdings that I set out in paragraph 29 of our skeleton. The judge referred to Minera Las Bambas, but again, we don't dispute that in general terms the correct approach. We just say that the upshot it is one where the judge fell into error. My learned friend relies in particular on the use of terms which have what he says are defined legal meanings in support of the judge's approach. I'll address you on that when we get to the context of the argument on public domain. But I would say in my submission, if a term has a defined legal meaning, we say at most that's no more than a presumption that feeds into the issue of contractual interpretation, and it's subject to consideration of the commercial consequences and business common sense. It's a factor that feeds into the iterative process as part of the unitary exercise of construction. And so it's not if the judge was right, sorry, insofar as the term public domain is certain enough to be of any use within contractual construction, we say it's not that promising in terms of an exclusion due to its uncertain nature. It's just one point that would be a starting point that feeds in. One still has to go through the process and test the commercial consequences of the competing instructions. So, dealing with where we get at 68, the NDA is in the form of a letter which is signed by Mr. Robinson on behalf of Altana and countersigned with acceptance by Mr. Amore on behalf of IX and Mr. Kastner on behalf of Brevent, drafted and amended primarily by Ms. Alabachka and Mr. Kastner, plainly based on a professionally drafted template or precedent. It was based on a professional template from IX, but in my submission, not considered. There's no evidence, and it wasn't held that it was considered by any legal advisor on the part of my client, and there's no evidence that specific advice was taken in the context of the JV. So we say it would be wrong, and I don't think the judge did this, but it would be wrong to treat the contract on the basis that each side had obtained legal advice or had considered the meaning of the term public domain or the effect of the law of confidence under equity on terms within it. Now, an important commercial context that's not mentioned by the judge when construing the JV, whether here or when addressing the public domain, the meaning of public domain, is who would be bringing what to the joint venture and what was intended to happen if the joint venture did not proceed. So on the first, as I've shown you earlier, that's what we can look at it within this, but the idea was that IX was to bring investment opportunities and Altana Wealth was to provide the fund structure. And on the second, as to what would happen if the joint venture did not continue, the context, we say, is that the parties should have been free to compete, subject to not using each other's confidential information. We say how that manifests itself is that neither party should be in any worse position than third parties as a result of the NDA. And so when looking at the exclusions, the idea was not to give anyone a particular bonus by reason of the signature of the NDA if the joint venture didn't proceed. It was that no one would be in a better or worse position than third parties. And we say this is of particular relevance because an effect of the judge's findings is that my clients were not free to invest in the opportunities with capital O, the bonds, that the judge himself held were in the public domain, even though there was, as we've seen in paragraph 95, an existing fund doing so, and even though there's a freedom to compete clause. So we say that that consequence, it's peculiar if the specific opportunities that are brought by IX to the agreement and to the JV and disclosed under the NDA and are held by the judge not to be confidential because of the exclusions, were nonetheless incapable of being traded in. We say that's an odd result. So the preamble is at 71. And again, from here, we see the emphasis is, in connection with Altana Wealth and its associated entities, together Altana and Brevent, and potential Venezuela-related credit investment opportunities, including but not limited to Venezuelan government, corporate bonds and claims and other Venezuelan receivables, private equity and other such Venezuela-related opportunities, defined term opportunities, to be sourced by Illiquidx. Confidential information, as defined below, will be furnished between Altana and Illiquidx, their respective representatives. And so the whole point is that specific opportunities were going to be provided. And the thrust of the agreement, the NDA, is to protect those, we say. The NDA, the judge says at 72, sets out a number of definitions, and it defines confidential information for the purposes of the NDA, confidential information, as follows, and sets it out. This is a very, very broad definition. Confidential information means any and all information relating to Altana and or to Illiquidx and or any opportunities. So it's not just information relating to opportunities, it's anything to do with Altana or Illiquidx, which is considered by the disclosing party to be of a confidential nature or is marked or described as confidential. So it doesn't have to be said to be confidential, it's just considered to be confidential. and furthermore includes without limitation, and then sets out at A to E various specific points. So A is information relating to Altana, B is information of whatever nature relating to Illiquidx or any of the opportunities that Illiquidx introduces or presents to Altana or Brevent, whether eventually invested in or not. So that it's not just information relating to the opportunities, it also includes other information relating to Illiquidx. And when the judge considered the business opportunity, he was clear that it was not an opportunity with a capital O that was being protected. It was protected as information relating to Illiquidx or any Illiquidx. So it's within that broader penumbra. And then E, important because the judge also looks at it, all Illiquidx intellectual property that is disclosed to or obtained by Altana. And again, Illiquidx intellectual property is very widely defined. And you see that under 74. Now, we say that the very breadth of that definition, defining the scope of protection, means that exclusions from that protection should be construed equally broadly. So it's a matter of principle, that's the correct approach. And the judge heard our submissions at that point and took the opposite approach. He said because of the breadth of the confidential information as defined, it suggested it was meant to be a high level of protection, and so exclusions were more narrowly considered. Then at 75, the judge turns to the operative provisions. He's right that they're not all relevant. Paragraph 1 is the only time I think we need to look at the document itself. By paragraph 1, he sets out Altana and Brevent were obliged to keep all confidential information confidential. I just want to show you where that actually is and the bits that the judge has missed out. So this is behind tab 11 in the core bundle on page 148 under confidentiality undertaking. So this is the primary confidentiality undertaking, which is then modified by the permitted disclosure under 1.1. But that's what feeds into all of the obligations in the NDA. And so this is confidentiality undertaking, page 148. Each party undertakes to keep all confidential information confidential and not disclose it to anyone, whether a person, firm, company, or any other entity, save to the extent permitted under paragraph 1.1 below. So you can't disclose. So let's just step back and think about the business opportunity at its broad level. You couldn't disclose that to anyone, save as provided under 1.1 below, and to ensure that all confidential information is protected with at least the same security measures and degree of care that apply to its own confidential information. So anything that falls within that is to be kept within, pursuant to, only disclosed under NDAs, kept confidential to the same level of care that the receiving party has. And that's a bit that the judge skipped out on as he was going through the need for the same security measures. And then B, to use the confidential information only for the purpose of sourcing, evaluating, and, as applicable, introducing or presenting opportunities, capital O, for permitted purpose. Now, focusing on specific confidential opportunities, and if limited to them, this undertaking makes a lot of sense on its face. If you're talking about specific opportunities, capital O, then you're not allowed to disclose the opportunities under A, except on confidential terms, but you can use confidential information for the purposes of sourcing, evaluating, introducing or presenting the opportunities. So you might promote more general confidential information without disclosing the opportunities themselves. But if you consider, so think about a specific confidential opportunity, you could promote a fund that would invest in such an opportunity, say some secret claim, without disclosing what that opportunity was, save under an NDA. So you could use broader confidential information for promotion without disclosing what that confidential information was. But if you consider the idea of an investment fund investing in distressed Venezuelan debt to be a business opportunity and confidential information, and it was confidential information as defined under the NDA, subject to any exclusions. So protected under the broad definition, and if that concept is not excluded by the permitted disclosure, one then wonders, how could the parties tell anyone about the fund? If the business opportunity is having a sanctions-compliant fund, you're meant to go out there and market it, that's the purpose. You're not allowed to disclose to anyone confidential information. That, to me, in my submission, that suggests that the exclusions under 1.1 must be construed broadly enough to allow the relationship to work. So, in my submission, the confidential information, such as the idea of an investment fund investing in distressed Venezuelan debt, business opportunity, could only be used for the purposes of presenting opportunities with a capital O if it were excluded under 1.1, unless you're putting an NDA on all of your marketing. And it's a strong indication, I say, in my submission, that those exclusions should be construed broadly in light of the breadth of the confidential information that is covered by the NDA at large. And I remind you that the judge held that the business opportunity was only protected as that kind of general confidential information, not as an opportunity with a capital O. Now, with that in mind, turn to the permitted disclosure. The undertakings contained in this letter shall not apply to any confidential information. In fact, we can go back to the judgment to do this, it's probably easier. So, tab 7, page 110, paragraph 77. Permitted disclosure. The undertakings contained in this letter shall not apply to any confidential information which, and then A, at the time of supply is in the public domain, B, subsequently comes into the public domain other than as a result of the breach of the undertakings contained in this letter, and then C and D, which we say are important but the judge did not pay the regard to when he came to assessing certain aspects of the detail, at the time of supply is rightfully in the receiving party's possession or control or was independently developed by the receiving party or its representatives. And then D, subsequently comes into a party's possession or control from a third party who is rightfully in possession or control of it and is not bound by any obligation of confidence or secrecy to Altana, Brevent or Illiquidx. So, public domain, the judge is right, it's not a defined term. An important point that I'll come back to is Malone Friend says that my construction of public domain, which I advanced before the judge, which is namely materials that have been disclosed without imposing an obligation of confidentiality on the recipient, he says that would rob this exclusion D, which is material that subsequently comes into a party's possession or control from a third party who is rightfully in possession or control of it and is not bound by any obligation of confidence or secrecy to Altana. Because he says that it robs that of meaning. In my submission, that's wrong, because D encompasses confidential information, so information that's not in the public domain on any definition, that is sourced from a third party. So it's not the case that D is rendered otiose if public domain means what I say. D protects information that has not entered the public domain, but nonetheless comes into a receiving party's possession from a third party who may themselves be keeping it confidential and who is not bound by any obligation of confidence to Altana, Brevent or Illiquidx and discloses it to them. And indeed, far from being something that cuts across my construction, in my submission, the scope of the exclusion under D aligns with my case on the meaning of public domain. Because in my submission, if public domain, which is what I say, it means that something is disclosed, it enters the public domain if it's disclosed without obligation to any third party. Imagine the position where one of the parties to the NDA discloses to a third party something without imposing an NDA, without imposing obligations of confidentiality, but that still retains some form of relative confidentiality. If that disclosure of information went to a third party who themselves do not owe any obligation to Altana, Brevent or Illiquidx, and they then disclosed it back to us, there's a clear mismatch between B and D. We'd be entitled to use it as being provided it by a third party, but only when the third party provided it to us, not when it had been disclosed more generally without an obligation of confidentiality under B. Now, we say the purpose of these exclusions taken together is to make sure that the parties to the agreement are not, by reason of the agreement, put in any worse position than a third party. And we say that's particularly important because of the broad definition of the confidential information. And it's particularly important when we get to consider the non-circumvent and the non-solicit and competition clause. So at 78, the judge addresses non-circumvent, and then at 79, paragraph 3 of the NDA is a non-solicitation and non-compete clause. 3A is not relevant, but 3B says the parties are free to compete with each other in the event that any of them decide not to jointly pursue the opportunities as defined, except that neither Altana nor Brevent can compete against Illiquidx using any of Illiquidx's confidential information. So that doesn't, it's a one-way clause, including, without limitation, any such confidential information which relates to any of Illiquidx's representatives, clients, contacts, investors, or acquisition targets, and or to any of the opportunities disclosed by Illiquidx to Altana and any Illiquidx intellectual property. So if the opportunities are in the public domain, as the judge held, if the bonds which were disclosed have entered the public domain, so third parties can trade in them through funds. On the learned friend's construction, and as the judge held, if they remain protected, because there's some relative confidentiality that remains, it would mean that my clients cannot compete pursuing the opportunities, even though third parties would be entitled to do so. And we say that is, even though this contemplates that the parties could compete in respect of opportunities if they were in the public domain, because they would be subject to, they could be subject to clause 1.1 exclusions. It's just the definition of public domain that my learned friend put forward and the judge accepted meant that my clients were not entitled to compete in respect of the opportunities, the only opportunities ever brought under the NDA by IX, because they weren't public domain enough, because there was some relative confidentiality left in them. And that, in my submission, it should ring alarm bells that information at the level of generality contended for by my learned friend, that was high level, not relating to the central purpose of the NDA particularly, should cut across competition on non-confidential opportunities, which is the result of the judge's finding.
Is this right? If the business opportunity, which is said to be confidential, is the opportunity to set up a sanctions compliant fund
My lord, yes.
to exploit undervalued Venezuelan debt. If that's confidential, then your client simply could not set up a fund,
That would be the...
a sanctions compliant fund
That
to exploit Venezuelan debt,
yes, my lord. That's the...
even though this clause said that they can, in certain circumstances, compete. I mean, what they would seem to be doing is, what this clause seems to envisage is that they will be competing, and since they're a fund, you'd think that they might be competing
As
by
a fund?
running a fund.
My lord, yes. And indeed, what's happening, why we say this is troubling is you get into this problem because the construction of public domain that the judge landed on, my learned friend suggested, which includes, so rather than being have you disclosed it without obligation of confidentiality, includes concepts of relative confidentiality, where it's still of some value to IX. And he said it was known, and there were other people doing it, but it was still of some value to IX. But on that basis, this is no freedom to compete at all, because as long as it's still of some value to IX to stop us competing, they can stop us competing, because we don't fall within the exclusion. It's entirely circular. And it flows from this idea of the breadth of the exclusions. Because you have broad confidential information, you should also construe the exclusions narrowly, the judge said. Whereas I submitted to him, and he rejected this submission, that if you've got broad confidential information, you have to define your exclusions broadly. It also, my lord, we would say that, leaving to one side the freedom to compete, we say this makes it difficult if the identity, being able to, if the opportunity to run a sanction compliant fund investing Venezuelan debt is confidential and has not entered the public domain, then how on earth can you promote the fund without disclosing that level of information? We're not talking about disclosing precise opportunities, which by the way were in the public domain anyway, but it just... Anyway. And the judge held that the business opportunity was protected, even though he held that it was known, and it was not protected in the detail, that such investments, the only opportunities provided, could be invested in without breaching sanctions. He held it was protected even though there was no special mechanism for trading without breaching sanctions that had been provided and was identified or pleaded as confidential. The only way in which dealing in these bonds was sanction compliant is because they were bonds that were not subject to sanctions. It's inherent in their nature. There was no special strategy on that. It's protected even though it was the appellants who were to bring fund structure expertise. So the fact that it's anything to do, that's what the joint venture provided. The fact that something to do with running a fund as opposed to, so these, the opportunities are known, but as soon as my clients try to put them in a fund, that's somehow confidential information. So again, it all seems inherently unlikely in my submission. So on the face of it, and indeed protected even though the judge held that none of the personal defendants was aware that what they were doing breached the obligations of confidentiality, because they didn't know that these things were confidential. On the face of it, we say a very strange result. And it is contrary to the purpose of this exclusion, we would say, which is to leave the parties in no better or no worse position than third parties if the JV doesn't go forward. So that brings me on to how the judge addresses the construction. Sorry, just while we're in the judgment, at 81, the judge holds that what opportunities are. Opportunities with a capital O are the specific opportunities within the general category of potential Venezuela-related credit investment opportunities. So that's what they were. And he says, it is common ground that apart from identifying 38 sovereign and paid evasor bonds, which are suitable for investment, which I consider to be opportunities, those are the opportunities holds are not in the detail, he says those are in the public domain. No specific opportunities were introduced or presented by IX to Altana or Brevent, although there was some discussion of specific opportunities by email. So they didn't bring anything to it. So IX provided my clients with things that were public, and then when the JV broke down because they didn't bring anything else, removed because. When the JV broke down and they hadn't brought any other opportunities, my clients were not allowed to compete with them using the public opportunities that have been identified to them. It's somewhat of a Trojan horse, one might say. So, paragraph 92 is where the judge addresses the arguments on public domain. It's on page 113. The defendant's case is that the business opportunity and all the information in the detail was in the public domain. There's no definition of public domain in the NDA, but the concept is well known to the law of confidentiality. See paragraph 124 of CF Partners. Information is in the public domain if it is so generally accessible that in all the circumstances it cannot be regarded as confidential. And you can see as you proceed in this paragraph, the judge takes on board, he's giving it a relatively secret, meaning information may be known or available to a number of people that may still be relatively secret. Even if there is some loss of secrecy, there may still be value to the person owed a duty of confidence in preventing further access to the information. The person owed a duty of confidence may suffer loss or damage or further loss or damage if the information is published more widely. In such circumstances, the information may remain confidential and subject to the duty of confidence. In terms of an exclusion, in my submission, that is that definition of relative secrecy in protecting confidential information as long as there is value to the person who had originally disclosed it. You're dealing with an exclusion that governs competition, the freedom to compete clause. It has the effect of removing any force from that exclusion at all, because it will always be of value to IX to stop my clients competing with them.
Can you help me on that? I take it you wouldn't dispute that that is the law as far as equitable obligations of confidence are concerned?
My Lord, yes, it is the law as far as equitable obligations of confidentiality is concerned. There's a little bit more to it than that, in that one has to bear in mind, if one's giving confidential information, public domain, that meaning, then when assessing whether something is in the public domain, the contextual nature, the highly contextual nature of the term, means it's flexible and uncertain of scope, but it does mean the more general the concept, then the less likely, we would say, it is that it is not in the public domain. So when assessing whether a concept has entered the public domain, you're dealing with something as extraordinarily broad and high level as the business opportunity, then that relative value, both in terms of the effect on the conscience of the person to whom it's disclosed, or indeed the question of whether in fact it's discernible or we consider by third parties to be protected by an obligation of confidentiality when disclosed to them, that's something that you have to take into account the level of detail of the confidential information. That's something that the judge, even on his own approach, didn't do when he was looking at the public domain.
Well, that's, as I understand it, is ground two.
Yes.
We'll come to that soon, I would hope.
Yes, sorry.
But can you answer this question? If this would be the position, if the parties were simply bound by equitable obligations, why can't they not enter into a contract to the same effect? What's the problem?
My Lord, the problem is, I mean, of course, it's possible for someone to enter a contract as the same as the equitable concept, but it is far from certain what the scope of the concept of public domain is. It's not a defined term in the sense of something bearing a single meaning. It's a flexible and uncertain approach. And so one might say, what's the point of these exclusions if what is done is to give the definition of confidential information such a very broad scope? Then it puts an undue burden on the contracting party and may render, in the light of this contract, because of the way in which it works, it may render the operation of the contract unworkable. So it's not that you can't agree that one might, though I think it's pretty undesirable, that one might define exclusions by reference to the equitable approach. But one then does have to look at the iterative process of considering construction, where that gets you and how that works in line with other provisions within the contract. And as I showed you on the overall obligation, if we're talking about relative confidentiality, well, it's still of value to one party, that means that something can be protected even if it's sent out to quite large numbers of people, as happened here. And that then means, well, how is it possible to comply on its face with the obligations of the confidentiality undertaking under 1, which says you mustn't disclose confidential information without imposing...
So the submission is it's all terribly difficult. But why is it any more difficult than for a party who's subject to an equitable obligation? Because an equitable obligation, as you accept, will protect something that has a relative degree of inaccessibility. And on your submission, our law of equitable confidentiality is defective, or
it's unclear, my lord,
because you don't know what you can do and what you can't do.
Well, my lord, speaking from experience in practice, it's uncertain. And often people wind up in court arguing about whether something has entered the public domain. That's not a good starting point for a contract that's attempted to regulise it.
So your submission is we should declare that the existing English law of equitable confidence is vague, uncertain, unworkable, and should reform it.
Well, my lord, perhaps that's for another day. I only have a certain amount of time. But, my lord, I get the point. I get the point, and it's a fair one. But one then looks at how that broad equitable definition interacts with the other terms within the contract, and if it renders those other terms unworkable, then something else should be, a different meaning should be given to it. And in aid on that, so if one looks at 1D, which I addressed you on earlier, the exclusion under 1D, that it's pretty odd if under 1B something is disclosed that has some relative confidentiality and remains protected, is then picked up by a third party who isn't under any obligation to Altana or Ix because no obligation of confidentiality has been imposed, and then sells it back to one of the parties. You get a different scope of exclusion under 1D and 1B. So there's something peculiar going on. And also, as I addressed you earlier on the scope of the confidentiality undertaking, it's difficult to see how, given the broad definition of confidential information, which includes things, and this is perhaps a point, it includes things that are on their face would never be within the scope of confidentiality, confidential information under the equitable duty of confidence. So this is not matters that are in fact confidential, start out as not being known or are hard to discover. It's anything that a party says is confidential. So the power and flexibility of the concept of public domain in the law of confidence as a matter of equity is brought to bear in relation to the exclusions, but is in no sense brought to bear in relation to defining what is confidential to start with. And that provides a tension. So, I mean, my lords, you have my submissions in terms of the construction, and I reiterate, I'll say it just once more, that in my submission, it's said by my learned friend that there's no textual basis for my construction. That's not correct. In my submission, my construction of public domain, which is that it covers anything that is disclosed to a non-party without imposing an obligation of confidentiality, that is consistent with the exclusion under 1D, 1.1D, which, again, that relates to matters that come into a party's possession or control from a third party who's rightfully in possession or control of it and is not bound by any obligation of confidence or secrecy to Altana, Brevent, or Illiquidx. It's all about whether third parties are bound by an obligation of confidentiality to Altana, Brevent, or Illiquidx. So, seeing whether there are further points. There were 4 points I wanted to make about how the judge's construction doesn't work within the NDA, but I think I've probably covered them. The first was looking at confidentiality undertaking under 1. We say it would render it impossible to promote the joint venture because the confidential information, in the sense of the business opportunity, could not have been disclosed to third parties, which seems odd. Second, we say it's contrary to the purpose of the exclusions under 1.1, which is, we say that the party should not be in a worse position than third parties. Third, as I've just said, it gives rise to this inconsistency between 1D and 1B. And fourth, we say that this, as a matter of commercial practicality, the effect of the judge's construction renders it highly uncertain what the scope of the permitted competition would be under the freedom to compete clause, and that it is commercially impractical that such a very broad definition of confidential information as it's contained under the NDA should not be reflected in a broad construction of the exclusions. And we can see there, let me just show you how the judge dealt with that. So I said that at 93, you can see my submissions recorded. The defendants, the judgment, this is at 113. Defendants say that the NDA is impractical if public domain is not given a more restrictive meaning. They say that the NDA should be construed so that information enters the public domain if it's provided to anyone not subject to a duty to treat it in confidence. He could not see any force in that submission. The definition of confidential information is wide. That indicates, as a matter of objective construction, that the NDA was intended to protect more information rather than less. It would be contrary to that intention to impose an arbitrary construction of the words public domain to cut down the amount of information protracted. So we say we fell into error there. One, it's not an arbitrary construction that I was proposing, and two, broad definition of confidential information gives rise to a policy that the exclusion should also be dealt with broadly. And then he rejected my submission that giving public domain its usual meaning would deprive paragraph 11A and B of any effect. And he said there's plenty of continued effect in paragraph 11A and B. And then ruled against me. You see that at the end of paragraph 93.
What would happen if the information was relevant information was sent to someone and they just ignored it or put it in a box, but they weren't under an obligation of confidence. It just went to one person and went no further. As I understand it, on your argument, that's then in the public domain for the purposes of the contract.
Yes, if it's sent out. So it's always it's a difficult approach, but you're right. It's an extreme case. But yes, if it's sent out without an obligation of confidentiality, the point is that third party would be free to use the information, and why should my clients, on the assumption it was sent out without breaching the NDA, so it's sent out without being in breach of provisions, which is what the exclusion requires, then it's not an unfair or uncommercial result, but the parties should then be allowed to use that. And it would have the effect of clarity.
Can I just ask, you were looking at 93.
Yes.
What is the support for your contention that if the if the confidentiality is widely drafted, you should construe the exclusions narrowly? Sorry, equally broadly.
Well, my lord, I could take you to one of the authorities my learned friend relies on, infinite land and artisan contracting. This is tab 5 of the authorities bundle. Let me just show you the head note on that. So tab 5, page 62, sorry, of the head note deals with the effect on conventional legal usage. They were considering the meaning of actual knowledge. So it says, per Chadwick and Carnworth, according to conventional legal usage, actual knowledge connotes a person's own knowledge as distinct from knowledge which the law attributes to him, either because he ought to have it, constructive knowledge, or because it's knowledge of its agent, and so on. So that's the point they were addressing, and then it refers to paragraphs 82, 87 to 88 post. If you turn up 82, this is where Lord Justice Chadwick was dealing with constructive knowledge and actual knowledge and the meaning of this exclusion clause at 7.4. And I rely on, so they were concerned as to whether or not it should bear the standard meaning. And then under H, he says, but on balance, I'm persuaded that that view is not correct. It seems to me that the distinction between actual and imputed knowledge in this field is so well known, see the analysis of the judgment of Lord Justice Hoffman, as he then was, that had the parties intended to include imputed knowledge in the qualification by which they cut down the scope of the relevant saving provision, so this is a qualification to cut down a saving provision, they would have said so. To my mind, the court should be slow when construing a qualification which restricts a saving provision, which has been introduced for the benefit of one of them, to give that qualification a larger meaning than its language necessarily requires. So so applying that to this situation, the exclusion is what's in the public domain. It's entirely in favour of IX, as you can see that when you're dealing with the freedom to compete point. And so an exclusion from that should be, so the public domain exclusion should not be given a broader meaning than is necessary. That's the principle I'd So in summary, we say the judge erred in his construction of public domain, but even if he was correct, as I'll explain under the next head, he erred in his application of that construction to the evidence for two reasons. One, it's his application of the construction to the evidence in relation to things that were in public domain, but he also failed to take into account the other carve-outs under 1.1 C and D in certain limited positions, and those are the bits at the back end of my ground one. So I'll deal with those first. So ground 1, little Roman 2. this is a heading in the grounds we deal with it in my skeleton. I identify 3 matters that were in the possession of Altana or Brevent because they've been emailed to them by third parties. So they were already in my client's possession and provided to them by third parties without an obligation of confidentiality to IX. And so we relied on those as carve-outs under 1.1c and d. They'd apply equally to public domain, at least under my client's construction, but I'm just going to address you on the 1.1c and d before I come on to public domain. Public domain will probably be after lunch. Let me deal with these. The overarching point, my learned friend says that these matters were not advanced at trial. They were before the court, were identified to the judge, but at the time of our written closing, my learned friend had not yet limited himself to the business opportunity. And the overarching point is that the business opportunity is eventually relied on in closing and considered by the judge was disclosed or excluded by these materials. And in each case, IX now seeks to avoid the consequences of that disclosure at the level of generality that's in these materials by seeking to incorporate further detail into the business opportunity. And we say it's not open to them for the reasons I addressed to you earlier. So Stiefel, these are 2 matters. It's at type 17.1 in the supplemental bundle, supplemental bundle, 17.1 and 17.2. These are a newsletter from Stiefel.
I don't have these supplementary bundle pages.
The pages are 90 and 92. So these are a newsletter and attestation form that was sent by Stiefel Financial Corp to Mr. Robinson. And they were referred to in our written closing in the context of the ability to trade in distressed Venezuelan debt being in the public domain. But the judge, we say the judge ignored the fact that the email also reveals that those assets that are referred to in this could be traded in by funds, because that's what's being dealt with here, which is essentially the business opportunity. So bear in mind that Altana is a regulated fund manager, and the only base on which they could trade in matters such as this would be as for a fund. And if you look at these documents at 90, so page 17, we have one, PDVSA, 8.5% 20, traded, round lot today in the 48 to 550 context, have more for sale. Yesterday traded Venice 18 in the 15 to 16 context. So these are referring to the bonds of the Venezuelan government and PDVSA ones, which are the business, the opportunities which the judge held were in the public domain. But these are sent to Altana, and then behind at 92, the next page informs the recipient how to attest to compliance with OFAC regulations and sanctions of Venezuela-related debt. And so here, in its entirety, if the business opportunity is pitched at the level of the ability to trade in a sanctions-compliant way in distressed Venezuelan debt, this is being offered by Stiefel to Altana, who are a fund manager. So whether or not there is some relative confidentiality that resided as between IX and Altana on Brevent in relation to these matters, this is coming from a third party to Altana. So, and so we say that this shows that bonds could be traded in a sanction-compliant manner, and how to do so. That's the attestation form. And the judge held that all the opportunities were in the public domain, the bonds that were disclosed, but he should also have gone on to consider this from the point of view, this material from the point of view of the business opportunity as defined, and it being disclosed to my clients by a third party, which had no obligation of confidentiality to IX. And again, what my learned friend says about this, he seeks to avoid the impact of this by trying to include further detail in the business opportunity, such as a rationale for investment, but that's just not open. So the next point on this, and I'll deal with the finish at lunch, this is multi-cell structures. Now this is not relevant as I understand to the business opportunity at all, certainly as the judge held it, but it is one of the points of the detail that the judge held in Schedule R, sorry, point R of the schedule to the judgment at page 132, that a multi-cell structure was confidential information and was misused by my clients launching a fund.
You say this isn't part of the business opportunity.
Yes.
I thought that when one looked at, was it A12 in the pleading?
Oh.
It might have referred, I thought it referred to the multi-cell point.
My lord, we say A12, although it's a reference, A12 says, let me read it, it's 197 behind tab 16. The implementation of the business opportunity was to be effected through a special OFAC sanctions-compliant investment vehicle designed and developed by the claimant, namely the Canaima Fund, which prototype structure they provided in confidence. So at the level of the business opportunity, that doesn't include
But
sales.
it goes on to say the fund was to be based in the Cayman Islands and to be a closed end, have a segregated portfolio company structure, which is the, as I understand it, the sell point.
Yes, but that's why this is relevant. We say that doesn't form part of the business opportunity. It forms part of the detail, because the judge didn't refer to A2 subparagraph 1, sorry, A12, he was just referring to A12, which when you see it at the other places, he referred to how this was open to my learned friend on the pleadings. For example, at A6.3, the claimant explained that the business opportunity was to be realised through an OFAC sanctions compliant fund. See A12, because it cross refers there. And then at the other place he referred to was at A33, the claimant showed the defendants how, by use of its investment strategy set out below, including the use of an OFAC sanctions compliant fund. So we say, although there may be reference to a long lock-up duration of 7 to 10 years, a cash sweep-up facility, non-retail, so on and so forth, that's not something that forms part of the business opportunity. Those matters as well, long lock-ups, and also there's no finding that we use those. But in any event, when it comes to multi-cell structures, we say, which is only to do with the detail, but even if you're not with me on that and you consider it as part of the business opportunity, the evidence of Altana was that running such a multi-cell fund was something it had been doing. A multi-cell fund had been done since 2014, and the evidence of Mr. Kastner, which I can take you to, was that, again, that such funds were known structures. So that's the, if the idea is there is something special about a multi-cell fund. The existence of and the use of those multi-cell structures was known on the evidence both to Mr. Kastner and to Altana and indeed Mr. Robinson, independently of anything that was being disclosed to them under the NDA. And bear in mind also that the purpose of the NDA and the purpose of the joint venture was that Altana were the ones who were bringing the fund structure approach.
My Lord, just in response to my Lord Justice Miles' question, could I just identify in the judgment, in the schedule, at page 132, the judge deals with multi-cell under claims management presentation, item R, and he finds that it was misuse. Yes, the use of a multi-cell structure was part of the business opportunity which the defendants have exploited. So he deals with that there. And I should say there's no appeal against that.
My lords, 1 o'clock, is that a convenient moment?
Yes. How are you doing time-wise?
I'm surprisingly, perhaps, doing all right.
Right.
I'm
I'm reassured. I'm very good. In that case, we'll resume at 2 o'clock.
obliged.